Good morning. My name is John Baza. I am the Division Director of the Division of Oil, Gas, and Mining. I will be acting as the presiding officer in this matter. Seated next to me is Elizabeth Harris, Assistant Attorney General, who is going to be representing me in this matter. This is an informal hearing in the matter of Granite Construction Company's notice of intention to commence small mining operations at the I-80 South Quarry, division file number S/035/0055. The sole purpose of this hearing is to hear argument from Granite Construction and the parties who filed formal objections with the division regarding their respective positions, so the division can determine whether Granite Construction/Tree Farm has met the small mine requirements. We recognize that there has been significant public interest in this permit process, and that members of the public may have come to this hearing with the intent of providing comment or feedback. Unfortunately, we are not taking public comments at this hearing. However, you are welcome to submit your written comments by sending an email to the division at oil gas mining, that is one word, no spaces or hyphens, oilgasmining@utah.gov. And I would ask you to do that by 5 p.m. on Monday, August 18th. I would certainly encourage that those providing written comments provide thoughtful and constructive remarks regarding this process. Repetitive or form emails are not really all that helpful in terms of making a decision. We will review and consider any comments received by the deadline. For those in attendance today, please remember that everyone is expected to behave in a courteous and professional manner. I will not tolerate behavior from anyone which threatens to disrupt the orderly progression of the hearing process or intimidates or harasses those who are participating. Anyone who cannot conduct themselves appropriately will be asked to leave. The hearing will follow this order. Granite Construction/Tree Farm will first be given the opportunity to discuss their small mine NOI and their position on whether or not met the requirements of statute and rules. Next, the 5 objectors will be given the opportunity to present their objections. My understanding is that the objectors have agreed that Salt Lake County will speak first, followed by Salt Lake City, then Mill Creek City, then the Richards Family Partnership, and finally, Save Our Canyons. Once we have heard from the objectors, the division will be given the opportunity to provide any information it believes to be relevant. And finally, Granite Construction/Tree Farm will have the opportunity to address any issues raised by the objectors or the division. Given that we have a lot of ground to cover, we're asking each party to limit their arguments to 10 to 15 minutes. Ms. Harris will be keeping track of time and will let you know when you have used your time allotment. I do not intend to issue a decision today. At the close of the hearing, I will take the matter under advisement and will issue a decision in order in the near future. Let me first ask if there are any questions on procedural issues we need to address before we begin.
I do have a question,
Yes.
Director Baza. The statutory scheme contemplates a 30-day period for the division to review and provide any objections to the small mine NOI, but you just mentioned that public comment would be taken and considered Monday, which is after the 30-day window. Could you clarify how those fit into the process?
Yeah, go ahead. Ms. Harris will answer that question.
It does contemplate that a decision be made within 30 days, but since we were required to hold a hearing under the procedural rules. They also allow for 10 days to issue a decision after the hearing. And so that rule is going to extend that time limit out. We anticipate that we will issue the decision within that time period.
Okay, so for our records, and maybe you can put this in a decision. I don't want to put you on the spot here, but we're just curious what the time frame is that the division will be working off of for its decision, for its ultimate decision. So 10 days from today, I guess, would be that time period that the division is using. But you can clarify that now or later.
Yes, I think Ms. Harris is nodding her assent on that.
Thank you.
Yes, you have to turn your microphone green. Mhm.
Thank you. Can you hear me? Are you picking me up?
Yes,
This is Mike Zodi on behalf of the county. I believe you had said August 18th for comments by the public.
July 18th, I believe.
Maybe I misheard. Did I
Oh,
mishear?
I did say August 18th, but no, I'm sorry, July 18th.
Okay, thank you.
That's this coming Monday. Typo. Okay, any other questions before we continue? Let me mention, and you've already brought it up, the microphone's in front of you. To use them, you'll push the button and it'll turn green. And that gives you the opportunity to speak into the microphone. And we are recording this meeting, so please be aware that you need to speak clearly into those microphones. We do have a court reporter who will be making a transcript of this for our records. And if you haven't already introduced yourself to the court reporter, maybe after the hearing, please come see her so that she has your name properly recorded. So with that, can each of the parties please state their name and enter an appearance for the record? And let's begin with Mr. Wallen.
Sure, thank you. Cass Wallen at the law firm of Parr Brown, Gee and Lovelace on behalf of Granite Construction Company and Tree Farm LLC.
My name is Michael Zodi. I am here with Samantha Haw. We are retained outside counsel for Salt Lake County.
Tim Bywater, and I am with the District Attorney's Office for Salt Lake County.
Trevor Gruel, I'm with the Attorney General's Office, and I'm representing the division in this matter.
Okay, and I'll probably have to ask each of the objectors when they get their time to introduce themselves at that point. Okay, so let's continue. Counsel for Granite Construction Tree Farm may proceed at this point. If you'd rather opt out of that, you can, but if you want to wait till everyone else speaks, that's okay.
Thank you. Maybe I'll just say a few things. I won't plan to take nearly the 10 to 15 minutes that we're allotted here, but I do want to mention maybe just a couple of things to set the stage, and hopefully this informs some of the comments that might be made today. I just want to underscore the fact that the process that the division is guided by when reviewing a small mine notice of intention is set forth in rule. That rule is R647-3-101. That rule provides that prior to commencement of operations, a notice of intention to commence small mining operations containing all the required information must be filed with and determined complete by the division, and the division shall have approved the form and amount of reclamation surety, period. So there are two requirements. The form must be complete and contain all the required information, and the reclamation surety must be approved. Please note that the division does not approve or disapprove of a notice of intention. Its role per statute and rule is to determine whether an NOI is complete. Also, please note the terminology used. This is not a permit application. This is a notice of intention to commence small mining operations. The division has been directed by the legislature to review such notices for completeness, not to determine on an ad hoc basis whether the division agrees or disagrees or finds policies that support or don't support a given notice of intention. The rule continues. It is recommended that the notice of intention be filed with the division at least 30 days prior to the planned commencement of operations. Subsection 2 of the rule says, within 15 days after receipt of a notice of intention, the division will review the proposal and notify the operator in writing, one, that the notice of intention is complete and all required information has been submitted, or two, that the notice of intention is incomplete and additional information as identified by the division will be required. That 15 days has come and gone, and the division has not notified the operator that anything is incomplete with respect to the notice of intention. Now, I realize that there's internal policy of the division and a statute that provides a different time frame of 30 days, but nevertheless, the rule says 15 days and the statute says 30 days. And I think the division's policy is to operate off of the 30-day time frame. But I do want to note for the record that the 15 days has come and gone, and there is no notice of incompletion with respect to this notice of intention. The rule continues. The division will review and respond to any subsequent filings of information within 10 working days of receipt. And then, here's the part that the division approves or disapproves. The division will review and approve or disapprove the form and amount of reclamation surety and all variances. There are no variances requested here, so that is inapplicable in this proceeding. So the only thing for the division to review and approve or disapprove, according to the rule, is the form and amount of reclamation surety. Now, this rule was implemented by a statutory structure, and the statutes provide similar requirements. Particularly, I would like to note Utah Code 40-8-13, subsection 5, which says, except for the form and amount of surety, an approval of a notice of intention for small mining operations is not required. Also 40-8-13, subsection 6, which provides for the review procedure of notices of intention other than small mining operations. I'd also like to note title in Utah Code Title 40-8-13, subsection 1D, which provides the notice of intention for mining operations other than small mining operations shall include a plan for reclamation of the lands affected as required by rules promulgated by the board. These sections of the code are self-explanatory. In the end, what we learn from these statutes and rules is that the division reviews and approves or disapproves of the form an amount of reclamation surety and reviews the notice of intention for completeness. There are other statutes that inform how the division has already determined what information goes into a notice of intention for large mining operations and what goes into a notice of intention for small mining operations. That decision has already been made, has made long ago. The division has followed that policy for decades. And the division would be violating equal protection rights of operators if it decides on a case-by-case basis, this small mine requires such and such information, and that small mine operation requires additional or different or more burdensome information. Small mining operators are entitled to have the same review process throughout a consistent regulatory structure. And the division has implemented that structure and has followed that structure for many decades. Part of that structure has been informed by Title 40-8-7, which provides that the division, the board and the division may require certain things. When that statute was passed, the division, together with the Board of Oil, Gas, and Mining, sat down and determined which items they would require and not require on small and large mining operations. And what came out of that were the forms that the division provides for operators to fill out for small and large mining operations. When a small mine operator fills out the form that has been provided by the division and has provided all the necessary information in that form, then that notice of intention is complete. And further information requested from the division would have to come through the process that's outlined in the rule. Notification within 15 days of additional information that's required, etc. So that's it. From our perspective, Granite has provided a complete notice of intention, has provided an adequate form and amount of surety following the division's recommendations on bonding. The notice of intention includes all required relevant information that the division deems necessary to determine an NOI to be complete. And since it has provided that information, according to the statutes and rules, Granite is entitled to move forward on its notice of intention. A final note. Several of the objections suggest incorrectly that as soon as the division issues an approval of this notice of intention, that mining operations will commence immediately. That is not true. When the division issues a notice that the notice of intention is complete and that bonding is sufficient, the operator then moves forward with any other applicable regulatory approvals required by other governmental entities. That is no different in this case. Upon approval, which we anticipate from the division, Granite would move forward with obtaining any other necessary approvals, including the Division of Air Quality, the Division of Water Quality, the Division of Water Rights, MSHA, OSHA, any other applicable governmental entity would need to review and approve the operations before equipment begins extracting or disturbing the surface or subsurface estate on the property. So to the extent that the objectors have expressed a concern that Granite would be moving forward without proper approval, that is incorrect. The prior practice of the division, and there are many approvals that have been given by the division in this fashion, provide that the division approves a notice of intention conditioned upon the operator getting other necessary approvals. And we anticipate that the division would provide such an approval in this case. We've never expected anything else. We've never expected the division to supplant the role of other governmental entities or overrule them or go around them in any way. So this is strictly and narrowly confined to what the division's rules provide, what the division's review is, and when the division reviews something and determines that it is complete, it is only with respect to the division's rules and nobody else's. Those other rules would apply in their own sphere. With that, we would respectfully request that the division issue a notice that the notice of intention is complete and the amount and form of reclamation surety is sufficient, and do that in the timeframes according to law. Thank you.
So, Mr. Wallen, I'd like to ask you a couple of clarifying questions, if that's okay. You mentioned two separate, well, not separate, but two decisions that the division has to make for a small mine NOI. One is to notify the operator regarding technical completeness. The other is to approve or disapprove the form and amount of surety. Is it your opinion that those things occur jointly, or do they occur separately with different timeframes?
Yeah, the way that I review or that I read this review is that the first step for the division is a review of completeness of the notice of intention. And that has particular timeframes set out in the rules and in the statutes. As I mentioned briefly, it's 15 days under this rule, 30 days under the statute. I believe there's a reason for that difference, combined with the 10-day period for the division to respond to additional comments. In my view, the way that the rule and the statute are harmonized is the division must complete its initial review within 15 days. An operator would then respond to any comments that the division has, and then the division would have another 10 days to address those comments, thereby fitting within the overall 30 days given under the statute. So a total of 30 days is how I read the rule and the statute combined. And I think the legislature did that on purpose. I think the legislature intended that small mining operations are reviewed on a streamlined basis because they're smaller disturbances. So that's the first step from the division, is to review completeness within the timeframe set out in statute and in rule. The second step would be to review the form and amount of reclamation surety, and the rules don't provide a time frame for that step. So I don't see any reason for the division to take longer than what is set forth in statute. I think if the statute says that the division has to provide all of its comments and its decision within 30 days, then the division should notify any objections with respect to the form and amount of reclamation surety within 30 days. But that is not expressly provided in the statute. I just think that's the appropriate reading given what the statute says. So, yeah, to summarize, I think both steps need to be completed within the 30 days. And the first step is expressly required to be done no longer than 30 days. And by implication, I believe the second step needs to also be completed within 30 days.
Thank you. So with that, let's turn to Salt Lake County.
Thank you, Director Baza, and thank you, Mr. Wallen. Since I'm going first, Director Baza, I'll do a bit more of the setup for the objectors, so I may take a little longer, and I hope you will indulge me in that. And I think they'd probably lend me a little of their time if necessary. But I'm going to go through a little more background, and I will get to the point, but I may take a little more time. And I'd like to briefly respond to a few of the points that Mr. Wallen made before I get into what I'd plan to present. I do think either a small mine NOI or a large mine NOI result in a permit. And that's just from R647-1-106, which is the definitions. And I think you will see that they call both a small or a large mine a permit by definition. And I've seen division documents stating that they are an approval or a permit, both, in letters approving, in our view, small mine application. So I just make that clarification. The points that Mr. Wallen raised about the process have really already been addressed, and those arguments have been made in the prior proceedings. And the board issued a really important order that I will get into today on May 23rd, 2022 on those points. So we take issue with that, and we rely extensively on the board's order already in related proceedings. Third, Mr. Wallen raised an equal protection argument. That has not been briefed. We've not seen that argument. If the division were to entertain that, I think we would need more process and briefing to address it. It's not clear that agencies can actually rule on constitutional arguments, but I think it would be something you would have to look into and maybe seek guidance from the parties. And Director Baza, you asked a question about, in Mr. Wallen's perspective, what has to be done by the division. The one thing I will note that I am not clear on is that in R647-5-101, subsection 3, it says certain adjudicative proceedings commence before the board, but follow the procedures for informal process in R647-5. And they include in that 647-3-111 surety form and amount. Now, I don't know exactly how the division and board square that language with the division and board's role, but technically it seems to be this is a board proceeding. I just don't quite understand the division's practice as to that. But I did want to just point that out since you'd asked the question, Director Baza. So as I indicated, I may take a little more time, and I appreciate your indulgence. I'm here on behalf of Salt Lake County. We thank you, Director Baza and the division, for convening the hearing. We appreciate the opportunity to be heard and to express our concerns today. We are here on a small mine notice of intent by Granite Construction, which lists Tree Farm LLC as the owner. Tree Farm was the prior applicant, as you know. The prior proceedings involved concurrently filed small and large mine permit applications. And that really led to some confusion, I believe, and challenges in trying to navigate the statute and regulations. And the board took that up on briefing and issued the May 23rd order, which is critically important. The county did not participate in the prior proceeding, but in a brief filed by Tree Farm on December 10, 2021, Tree Farm had asserted the county had no land use authority over the property at issue, and argued they had a vested mining right. The county disagrees with Tree Farm's assertion The county does have land use authority and is here to protect it in this proceeding. As noted in the county's objection and hearing request, Tree Farm has filed a lawsuit seeking to strike down a recently enacted county ordinance, ordinance number 1895. What that ordinance means and its relationship to this proceeding is something that will need to be considered. But that lawsuit has not been served yet. So while the lawsuit has been filed, I believe it was in May, around May 22nd, I think. Whether through that lawsuit or a land use application to the county, the issue of the county's authority is going to need to be resolved as well. And there's clearly a live dispute, I think, between the parties, Tree Farm and Granite and the county. And in fact, as reflected by a lawsuit, Tree Farm's prior assertions in this proceeding. So, by appearing here today, the county's not waiving any of its positions or the impact of that ordinance, but I wanted to bring it to your attention. As to the current small mine notice of intent, the county's concerns are stated in the county's brief at pages 5-6. And the County Planning Commission indicated its concerns with a mine in the Forestry and Recreation Zone include concerns about increases in air and dust pollution, increase in noise pollution, a threat to protected watersheds, depletion of water supply, an increase in wildfire risk, increased risk of avalanches and rock slides, an increase in traffic, loss of wildlife habitat, and destruction of the landscape and ecology. So in terms of the county's interest, I just want to make it clear, the county has articulated its interest in a mine in this zone. So let's get to the board's May 23, 2022 order. And as I have indicated, it's a critically important order for today's proceedings and as the division and the board set the stage for going forward. That board's order discussed the process and protections that should be considered to be followed in this specific small mine notice of intent. This is a final order. It was not appealed, so it is binding in this proceeding. Any doubt about that was put to rest on page 13 of that order. And I'll read it to you, Director Baza. This is from the order section. Based on the analysis contained herein, and for good cause shown, it is hereby ordered that Tree Farm and the division stipulated motion to dismiss is granted, with any evaluation of a resubmitted small mine NOI from Tree Farm be performed consistent with this opinion. We're talking the same mine, the same property owner. So this opinion has to be followed, and it's an order, and it's final. So we've been given guidance. You've sought guidance before you've got the guidance from the board. The board recognized this is a unique situation. Small and large mine permits were filed concurrently, and that was unusual. It's a sensitive environment in Parley's Canyon. And so the board recognized there could be protections to make sure the objectives of the Mine Reclamation Act are achieved. The board's order outlined a process whereby the division could order that additional protections and process be provided. And the board referenced a notice of agency action that the director could issue or similar order. And I think you could just, because we have a proceeding going, just make the order from this proceeding that then gets appealed up to the board, pretty much regardless. But I think that's a form that you could follow, is just encapsulate what we're asking for in that order at the end of the day. And then as the board suggested, it would review that and see if it agrees. And the board outlined that at pages 9 and 10. If the division determined the situation called for broader review and approval, after receiving a small mine NOI, Utah Code 40-8-7 authorizes the division to file a notice of agency action or similar filing regarding the proposed small mine. Thereafter, following briefing and a hearing, the board can evaluate and determine if the additional protections are warranted. So I think the process has already been explained by the board. The county agrees that the additional protections are warranted here and makes the following specific requests for relief. And consistent with your hearing notice, we're going to explain the exact basis for each one. And I will try and be as quick as I can. First, to address the objections that have been filed fairly and fully, the division should order this informal proceeding be converted to a formal one. And that is allowed in Division Regulation R647-5-105 entitled Conversion of Informal to Formal Phase. And it says, anytime before a final order is issued in any adjudicative proceeding before the division director may convert an informal adjudicative proceeding to a formal proceeding if conversion of the proceeding is in the public interest and conversion of the proceeding does not unfairly prejudice the rights of any party. I think the board has expressed and encapsulate that it would be in the public interest. And I think you can see this from pages 1 and 2 of the board's order. This is the paragraph starting on page 1 where it says, in essence, and then it continues down through the end of that paragraph. And the board cited the unique geography of the proposed mine location, the timing with the 2 prior applications being submitted concurrently, and then public safety. And the board said as to that, the application processes commensurate with this matter generated significant public comment and opposition to the proposed mines based on concerns over public health and safety. The board is unaware of another matter that has generated this level of public concern or public interest. And so when you think about whether the showing that it's in the public interest to convert this to a formal proceeding, if that's been met, I think the board's order is strong evidence of that, and it's based on the prior briefing too. So I think that finding is there. It will not unfairly prejudice the rights of any party. All parties will have the ability to put on evidence, present information and argument. And given the unique situation here, if there is a time to convert an informal proceeding to a formal one, it seems like this would be it. So that's our first request. In any proceeding, we think there should be additional information and evidence taking, including potential expert evidence, including regarding reclamation and operation plan issues. And so we think that opportunity should be presided, whether it stays informal or goes formal. The county understands the hearing today to be the opportunity to follow the board's order to set the remaining process. And then the substantive arguments will really follow depending upon how that is defined through this hearing, your order, Director Baza, and then how the board handles that order. Okay, the second request for relief that the county has included in its objection and request for hearing is an order that a site-specific reclamation plan be submitted by the operator in this case. And I'm going to start first with the board's order as support for that. That's and on page 10, the first full paragraph, item 2, the board says if the board concurs with the division on this order going up to the board, additional regulatory requirements under Utah Code 40-8-7 become available, including for mining operations, including small operations, the furnishing and maintenance of reasonable surety to guarantee the land affected is reclaimed according to approved plans consistent with on-site conditions. And that focus on on-site conditions is stated several times in the statute, and I will just walk those walk through those with you right now. First of all, Utah Code 40-8-2, subsection 3, the final sentence states, reclamation requirements must be adapted to the diversity of topographic, chemical, climatic, biologic, geologic, economic, and social conditions in the areas where mining takes place. To accomplish that, particularly in this unique environment with a mountain community right next door, a site-specific rec plan is in order. Likewise, Utah Code 40-8-7, which the board relied upon extensively, sub 1, section C, says the board and division may require for mining operations, including small mining operations, the furnishing and maintenance of reasonable surety to guarantee that the land affected is reclaimed according to approved plans consistent with on-site conditions. We don't see any evidence of any tailored plan at this stage in this proceeding. And lastly, Director Baza, Utah Code 40-8-12 states the objectives of mine land reclamation are to return the land concurrently with mining or within a reasonable amount of time thereafter to a stable ecological condition compatible with past, present, and probable future local land uses. Again, there's very clear focus on site-specific conditions, and I think we need to see a reclamation plan to assure those interested, the governmental interest, other interests, that the site-specific conditions are being considered. In developing a site and approving a site-specific plan, the division is empowered, and the statute says, should consider any other reclamation requirements. This is, again, assumes we get past the dispute with Tree Farm and Granite over the county zoning authority in these other proceedings. But once we get past that, the statute says, Utah Code 40-8-14, subsection 4, in determining the amount and form of surety to be provided under this section, consideration shall be given to similar requirements made on the operator by landowners, governmental agencies, or others with the intent that the surety requirement shall be coordinated and not duplicated. There's no evidence of record that any coordination or consideration of, for instance, any county reclamation requirements that would apply. And I would direct you to the Foothills and Canyons Overlay Zone, Chapter 19 .72.110E, entitled Reclamation, Revegetation and Land Reclamation Plan. So we believe a site-specific reclamation plan is called for by the statute. The board's order allows a process to have that. Given the prior confusion over small and large mine in this situation, it is unique, and we think it would be appropriate. I have my third request and my fourth request, and I will again keep moving. We also ask in our papers that the division order that a separate site-specific operation plan be submitted. And again, the board order, page 10, I'm going to quote paragraph number 4. If the board concurs with the division, additional regulatory requirements under 40-8-7 become available, including that mining operations be conducted, i.e. during the life of the mine, to minimize or prevent hazards to public health and safety. The standard form that's been presented here does not provide adequate detail in this sensitive and unique environment next to a mountain community to help everyone understand what those protections will be, how they will be defined, and how they could be enforced. So I believe given the board's order and the statute, that a more detailed operation plan would be appropriate here, and that you should so order. We will make a few comments on the small mine notice of intent form. In section 3, Roman 3, subsection 3, the original notice of intent filed in November of 2021 indicated that the amount of material to be extracted, moved, or proposed to be moved is up to 200,000 cubic yards. I'll just sort of restate that. So in the November 2021 original small mine notice of intent, the operation plan, Roman 3, sub 3, said the amount of material to be moved is up to 200,000 cubic yards. The pending small mine NOI does not give an amount of material, and instead says to be mined consistent with R647-3-114. And that is a provision regarding mine enlargement. And it says before enlarging a small mine operation beyond 10 acres of surface disturbance in an incorporated area of a county or 20 acres in an unincorporated area, the operator must file a notice of intention to commence large mining operations. It is confusing to us why this would be inserted as opposed to an amount for a small mine, and why it would reference the conversion process to a large mine, seemingly bringing the large mine concept back into the small mine proposal. Also note that section 3, number 4 in the current small mine proposal does not describe the liquids, chemicals, reagents, or other substances to be used, including fuels. It just says water will be used in the mining, but nothing else is delineated. And lastly, section 3, number 10 says completion date is unknown. It would be useful to understand what that anticipated completion date would be. So the fourth and final request the county will make to you, Director Barza, today, and Mr. Wallen has already touched on this, and we appreciate him laying out the intention of Granite and Tree Farm to follow other approvals. You know, interestingly, there was no mention of the county, which is an issue that needs to be resolved. But we do think it would be appropriate to order in any approval, if we ever get to that, that any mine approval state no activities can be commenced until all other approvals by other agencies are obtained. This is a very important point for the county, as you may imagine. The board order at page 11 directly contemplates this and says, the board interprets, this is on page 11, Utah Code 40-8-7, the board interprets this statutory provision as requiring approval of any permit that may be required from sister regulatory agencies to be of record prior to the commencement of mining operations. And that's also supported by Utah Code 40-8-17. And there is we look to the records, and there is an example, and Mr. Wallen recognized this. One, for instance, is from May 26, 2021. This is for the Harbor Light Perlite Pit matter S/045/0044. It states in relevant part, you are now permitted to conduct mining activities as outlined in the notice, provided you have approval from all other appropriate agencies, including any Tooele County requirements, such as the relocation of a Class D road. So we think any final order at whatever point that might issue, if it allows this to move forward in this proceeding, would need to have similar language. So I was going to make a point about trying to get clarity on the intentions of Granite and Tree Farm as to other approvals. Mr. Wallen has already addressed that, so I will not touch on that. So just to summarize, the county is asking the division director to issue an order that would convert this proceeding from an informal proceeding to a formal one, allow further briefing and evidence on the substantive issues, order a site-specific reclamation plan be submitted and approved through this proceeding. Any surety amount be adjusted to reflect that site-specific reclamation plan, and a site-specific operation plan be submitted and approved through this process. And lastly, that the order make clear no activity can happen on site until all other required approvals are obtained. That's all I have. I thank you for the opportunity. I'd welcome any questions.
Thank you, sir. I appreciate the raising of your points. I do have some questions, but I think I'm going to withhold them until after we hear from the other parties, and especially the division, to see if there's any response to some of the issues you've raised. So with that in mind, let's move on to Salt Lake City and hear your presentation.
Thank you.
And if I can just add, we did allow you to go over time on that, but we are running a little bit late. So if everyone can do their best to be concise, thank you.
Good morning, Director Baza. Thank you very much for the opportunity. My name is Mike Lee. I am with the Salt Lake City Attorney's Office and represent Salt Lake City Corporation in this matter. And here with me today is Mark Cottrell, also with the City Attorney's Office representing Salt Lake City Corporation. Again, we thank you for the opportunity to convene this hearing and allow Salt Lake City and the other objectors to present their concerns to you directly and on this NOI filed by Granite. We are here as an affected person under Rule 647-5-106.4 because we will be directly impacted if this proposed mine is allowed to commence. And we have legitimate concerns about it and how it will impact public health and safety. We've presented our concerns in our written objections, which you received over a couple weeks ago, but I do want to highlight just a few of those for you today. So Salt Lake City is in a unique position because we provide water for hundreds of thousands of residents, businesses, and visitors throughout Salt Lake City and throughout several nearby cities within the county. Many of our primary water resources, including watershed and water reservoirs, are located in Parley's Canyon, adjacent to the proposed mine location. Over the years, we've invested hundreds of millions of dollars to develop our water resources and infrastructure, which includes the ability to effectively treat and convey water from Parley's Canyon watershed and other nearby watersheds. Now, even without the proposed mine at issue before you today, our water supplies are already at risk. We've projected by the year 2060 that we will not have sufficient water for our customers unless serious water conservation practices are employed. In addition, our watershed in Parley's Canyon has been greatly impacted by not only overuse and development, but also climate change. Those are the issues that we as a city are dealing with now. But when you add the proposed mine that's at issue before you today, those significant concerns are greatly exacerbated and will only become more of an issue as the time goes on. The proposed mine will make it much more difficult for Salt Lake City to fulfill its obligations under state and federal law to provide clean and safe water to its customers and to protect public health and safety. The proposed mine will threaten Salt Lake City's watershed and Parley's Canyon. In particular, we are really deeply concerned about potential fugitive dust emissions that could arise from the proposed mining. Our water reservoirs in Parley's Canyon are open, and so they are open to dust deposits that can pollute the water within it and impact our water quality and our ability to treat that water. And as another example, the dust will likely accelerate the melting of snow, and that is relied upon by the city to provide water to its customers during the summer months. Now, if the snow melts earlier than anticipated or expected, then that will result in less available water for our customers when we need it the most during the summer. So these concerns, I've just briefly summarized these concerns, which are outlined in our written objections. These are significant, but they are also nothing new to Tree Farm and to Granite. The city raised these identical concerns earlier in the proceedings with Tree Farm's small mine NOI, in which we were successful in intervening and presenting these concerns. But how does Granite address these concerns in its NOI? Well, looking at their NOI, they don't really address them at all. So Mr. Zodi pointed out to Section 3, and in there, there's a section about water and what chemicals, what liquids will be used. And all they say is that water for fugitive dust control will be used, and a stormwater pollution plan and a spill prevention, control, and countermeasure plan will be developed. But there are no more specifics about what that really means. What kind of plans do they have? What are they planning to do? And frankly, where will they get this water to mitigate fugitive dust emissions? It's not clear. And these basic, vague, nondescript representations in their NOI does nothing to assuage Salt Lake City's significant and serious concerns. Salt Lake City is the primary water rights holder in this area, and any water right claimed by Granite in the NOI is inadequate to meet the operational demands of their proposed mining operation, and presumably any future large mine that may be contemplated but strategically has not been submitted at this time. So the city has previously affirmed these water rights in the general adjudication action filed by the state engineer. And based on our preliminary review of the water rights, it's our understanding that Granite itself does not possess any water rights in this area. And also the Tree Farm, which is the landowner where this proposed mine is to be located, has very limited water rights. And so whatever water rights Granite and Tree Farm may have will be inadequate to address to satisfy whatever they would need to mitigate fugitive dust emissions and operate this proposed mine. And Salt Lake City cannot make this water available to the proposed mine. We're obligated to provide water to our customers who are within our designated water service area. And city ordinances limit us from providing any additional water to anyone outside that area. And this proposed mine would be well outside the designated water service area. And so we would not be able to provide that any additional water that would be needed to mitigate the dust emissions, which if that's unmitigated, then that will create further issues, further pollution, and further jeopardize our water resources nearby. So I'd like to turn to the specific questions that were raised in the notice of hearing in terms of the relief we are specifically requesting and the legal authority and basis for that. Mr. Zodi did an excellent job in outlining those requests and the legal bases, and Salt Lake City joins in Salt Lake County's requests for relief. And I'm cognizant of the time, and I don't want to repeat everything here, but I do want to highlight a few points for the director's consideration. In terms of the board's order, the May 23rd order, I found it interesting that Mr. Wallen did not mention that once in his presentation. And it is clearly front and center at issue in this proceeding. That order, as Mr. Zodi said, is applicable here, and it is a final non-appealable order, and the division is bound to follow the terms of that order. Utah Code Section 40-6-15 provides that the division shall implement the policies and orders of the board. So the division here should follow the board's order, and which is the May 23rd order that we are talking about. And Mr. Zodi also mentioned that the final order within that opinion, the May 23rd opinion, in which it said that any evaluation of a resubmitted small mine NOI from Tree Farm be performed consistent with this opinion. I think that's key, crucial language to zero in on. Now, Mr. Wallen may not have mentioned the May 23rd order because he's here representing Granite. And perhaps he thought that Granite is not Tree Farm, and therefore this order does not apply. But if he were to make that argument, I would submit that it does apply. It is directly applicable here. Granite's NOI was submitted last month with the same exact location as Tree Farm's prior NOI. In fact, it lists that Tree Farm is the owner of that location, so there's no secret about that. And back in January, when Tree Farm amended its large mine NOI, it expressly named Granite as the operator of that proposed large mine. So there were several media articles around that time in January talking about Granite being the proposed operator for Tree Farm. So it's not the case where they are separate and independent actors who happen to be here. It is the case that Tree Farm and Granite are working hand in hand. They are joined in the hip, so to speak, and that this order from the board on May 23rd should also directly apply to Granite in this application. And substantively, I don't want to rehash everything, but I do want to emphasize that the board laid out clearly in certain circumstances, and we believe this is one of those certain circumstances that the division has the option to initiate a notice of agency action or similar filing for further process, for further briefing, for further evidence to be taken in, so that all of our interests, not just Granite's, but all of our interests and the public's interest can be considered and weighed before any decision is taken. And we agree also with the county that this hearing, all informal in nature, can be converted at your discretion into a formal hearing before the board, so that all these issues may be laid out. In terms of public interest, it's clear that there is significant public interest. As the director's introductory remarks stated, that there is high public interest in this. That's also evidenced by the amount of people who are present here today, who can't even have the opportunity to present actual public comments to you, but they are here because this is significantly of interest to them. And we agree with the county's assessment that there would be no prejudice. Every party would have the opportunity to present their issues and arguments. So again, I don't want to belabor the point, but I do want to just reiterate that we fully join in and adopt the county's requests for relief from the division, and ask that basically, in sum, that we be given more opportunity, more of a process to present our issues. We're happy to present as much evidence as is required in order to fully understand, for everyone to fully understand our concerns. And so following the board's May 23rd order, converting this from an informal to a formal hearing, and if for some reason the division does permit the NOI to proceed, that any approval be couched with various certain conditions, including that Granite obtain all necessary approvals that would be required before any commencement of mining. So that is my presentation. I'm happy to answer any questions, and thank you for the opportunity.
Thank you, Mr. Lee. And again, I will withhold questions because I'd like to hear how the division may respond to some of the points you've raised. So thank you very much.
Thank you, Mr. Director.
We'll move on now to Mill Creek City.
Thank you, Mr. Director. My name is Artemis Vamianakis from the law firm of Fabian Van Cott. We are outside counsel for Mill Creek City. I first want to join in the other objectors and parties here today in thanking the division for hearing us during this informal hearing and providing us the opportunity to present our objections and arguments here today. For the sake of brevity, I'll let you know that we concur and join in most of what's been said today by our fellow objectors, Salt Lake County and Salt Lake City. And I do want to just raise a few and highlight a few of the concerns raised by Mill Creek and its individual objection. The city of Mill Creek has more than 63,000 residents located in Salt Lake County. Borders the mouth of Parley's Canyon, and a significant number of its residents live in that canyon rim area. So they are particularly concerned about this small mine NOI presented here today. Concerned with the environmental impacts, particularly the air quality from mining in the canyon. Mill Creek residents have been adversely impacted by fugitive dust emissions emanating from the existing rock quarry and mining operations that are just across I-80 from the site that's described in Granite's small mine NOI. In that instance, this other mining operation had been cited for excessive dust and violations of air quality regulations. And this dust contributes to the poor air quality by introducing particulates and creating nuisance dust on cars, homes, windows, etc. And this dust is blown down into Mill Creek neighborhood by the wind that comes down the canyon. And these concerns are similar to the concerns that would be posed by the present small mine NOI. With respect to the relief requested, the city of Mill Creek expressly joins in and adopts the relief requested and the authority to justify the relief requested as presented by Salt Lake County. We join in that request wholeheartedly. A couple of points on my end before I leave the table for the day. The city of Mill Creek ultimately wants to ensure that the board order is adhered to. Mill Creek was a party to that prior board proceeding, and it has an interest in making sure that the authority that is binding authority is adhered to strictly. In that board order, the board interpreted the Utah Mined Land Reclamation Act and specifically affirmed its statutory authority to require that mining operations be conducted to minimize or prevent hazards to public health and safety. The board affirmed that the board and the division is not a rubber stamp, that it can exercise that authority to ensure that those protections are in place. And as the Salt Lake County and Salt Lake City made clear, just reading the form of the NOI, we cannot be sure that those protections will be in place. And we cannot be sure that the public health and safety of the residents of the city and Mill Creek will be protected. And therefore, unless there are further questions, the city of Mill Creek would just respectfully request that the division grant the relief requested as set forth by Salt Lake County's representative here today, and based on the justification and the authority so provided. And unless the director has any questions, thank you very much for your time.
Good morning, Director Baza. My name is Evan Strasberg. I'm with the law firm of Michael Best and Friedrich, representing the Richards Family Partnership. Briefly, again, like the others, I want to thank you for the opportunity to be heard today. And I will keep my comments brief because I think the other objectors have done a very good job of raising what we think are the key issues. But just very briefly, Richards Family Partnership owns approximately 660 acres of what is largely pristine, undeveloped, undisturbed property that is either directly adjacent to or in close proximity to the mining operation at issue. So the issues that have been raised by the other objectors, which we certainly agree with, and which we certainly agree that the other objectors have standing to raise and have legitimate interests to address, all of those concerns are felt most acutely by my clients. Because it is their property that is directly adjacent. So when we talk about things like what might a mining operations plan look like, what might reclamation plan look like, those things are of particular importance to my clients because they're the ones who are going to be dealing with these issues, both during operations if they ever commence and after when reclamation occurs, they'll be dealing with those things on a daily basis. So they have a very real concern with respect to what's going on up there. And really, I think what we want to make clear is what we're asking for here is very simple. And I think that the order that the board issued really makes your job, I think, pretty easy here. It really laid out exactly what should happen going forward. And that is that this needs to be a more formal process. There needs to be an opportunity for presentation of evidence. We understand that this is, we're limited in what can be done and said here and who can present. That is a function of something none of us have any control over. But what there is the opportunity to do, and what the board gave you the opportunity to do, is make sure that every voice that needs to be heard is heard. We have very few people who are given an opportunity to speak today. And by virtue of the number of people who are here, not to mention however many more may be participating and observing, and by what we saw the last time this came up before a hearing, there are a lot of people who are concerned for very good reasons. And all we ask is that they be given the opportunity to be heard, and that this be fully vetted in an appropriate forum before any operations are allowed to commence. And I just want to speak very briefly about the comments that were made by counsel for Granite and Tree Farm at the outset. I sort of feel like it's from the scene from The Wizard of Oz. Pay no attention to the man behind the curtain. Let's ignore what the board already ordered. Let's ignore what's already happened. And let's ignore what Tree Farm has already said about its intentions with respect to this mine. We are here today on a small mining notice of intention, but we know what their intention is. It's to have a large mine, a very large mine, for a very long period of time. They've made that clear. And let's not ignore that. Let's not ignore what the board already ordered. Let's follow that to the letter so that we have an opportunity to ensure that things like what the board mentioned, mining operations be conducted to minimize or prevent hazards to public health and safety, can be fully vetted and considered before operations ever begin. Because I think we all know once operations begin, it's a lot harder to stop them once they've begun than to simply ensure that the right process is in place and the right issues are addressed before that ever begins. Thank you.
Is this on? Okay, last but not least, thanks for having me today. I am Janelle Urick-Bauer. I represent Save Our Canyons. I think that everything has been pretty well covered here today by the other objectors, and Save Our Canyons would like to adopt and incorporate all of the arguments made here today on, as well as everybody else on our behalf. I just have a couple things I wanted to bring up. The division's authority to require more process for this NOI comes from Utah Code 40-8-7, Part 1A. So we are asking the division to process this SMO as contemplated in the board's order, given the breadth of the order and the unique characteristics of this mine. That part of the code says the board and the division may require that a notice of intention for all mining operations be filed with and approved by the division before the mining operation commences. And then it goes on to cite sections 40-8-13 and 40-8-23, which are the specific mining activity sections. But that general authority cannot be ignored. And I think counsel for Granite is trying to ignore that authority, saying that the division is violating the equal protection rights of Tree Farm here by requiring some other authority. But the canons of statutory construction, which are adopted in Utah and well known to all lawyers, require all parts of the ordinances to be harmonized and read together. And the board's order is clear. And it's our argument here that that part of the code allows the board to take a unique mine and process it with more safeguards for the public, more input and more process, so that a large controversial mine cannot go into a neighborhood without people being involved in the process and understanding what is actually going to happen on the ground. like the Richards Family Partnership just said, we believe that this notice of intent for a small mining operation is actually just part of the phased mining plan that Tree Farm had at the beginning of this process. And the notice of intent, as Salt Lake County reiterated, mentions R 647-3-114, which is the enlargement process to change a small mining operation to a large mining operation. They're still playing this game with you that they're going to file this small mining operation notice of intent and then move to the large mining operation. We don't understand the game, but we want to know what's involved here. We also agree with Salt Lake County's arguments that the surety in this case is way too small. I believe it's $352,000. I don't think you can even buy half a condo in Salt Lake Valley for $352,000. I'm not sure how they're going to reclaim this property for that much. And given the unique situation, the health risks, and all of the other issues raised by Save Our Canyons and the public, I just don't think that that is enough for this mine. And finally, Save Our Canyons interests here. Since I'm last, in a non-disruptive way, I'd like everybody in the public, in the audience here today that thinks that they're going to be negatively affected by this mine to stand up. Everybody online, you can turn your cameras on so we can see your faces if you think you're going to be negatively affected by this mine. This is a huge issue for the Salt Lake Valley. All of these families, all of these people deserve to be part of this process, especially since we know what Granite is doing here. We know that this is going to be a large mining operation. And I think that's all that Save Our Canyons has today. Thank you.
Absolutely. So just to start off with some of the things that Granite has brought up, and Granite is correct in stating that the administrative rules require 15 days for the division to notify, but the statute seems to conflict with that, offering 30 days. The division appreciates the attempt to harmonize those two, but to the extent there is a conflict, the division believes the statute trumps the regulation and that the division has acted properly in this instance, given the procedures required, especially in conjunction with the Utah Administrative Procedures Act, which in this instance seemed to require an informal hearing be given to the objecting parties and seems to stay the proceedings or the clock, adding 10 extra days. So the division believes it has acted completely properly, not only in regards to the process, but overall in regards to reviewing and the requirements that the division has in this instance. With Director Baza, with your permission, I'd like to approach and give you several declarations, as well as all of the objecting parties and Granite a copy of these declarations by division staff. Would that be okay?
Yes, I think I trust you, Trevor.
Could you remove Seth's and then hand out to the other parties? So just remove the last two. Okay, thank you. Before jumping into these two declarations, I'd also like to note, and this has been touched on by other parties, but the equal protection argument. In this instance, the division does not believe there is a valid equal protection argument to be raised, but to the extent Granite wants to bring forth such an argument, additional briefing should be required. Normally in an equal protection argument setting, there's a requirement that there's a protected class. No such class exists here. The division does maintain, however, that it needs to act consistently, needs to avoid acting arbitrarily and capriciously, and has done so throughout this entire process and strives to continue to act rationally. Granite brought up a really important point that has been touched on by the other parties. Approval of a small mine NOI does not mean that groundbreaking is going to immediately take place. Granite will be subject to other permit approvals, or whether we want to call them permits or not, other approvals from sister agencies and other governmental entities. That is spelled out in statute. It's required in the current board order, and Granite accepts that. The division maintains that, and frankly could not grant approval that would remove another governing body's ability to act and regulate. Switching gears to some of the objecting parties' arguments. So first, with Salt Lake County, one of their requests for relief is to convert this from an informal setting to a formal setting. Salt Lake County has accurately described the process for evaluating that. And I would note that that decision can be made anytime up until the issuance of an order. What's not clear in that process is what additional process would be given should that request for relief be granted. And what I mean by that is, in theory, under the rules set forth, a hearing examiner could convert the process from informal to formal after the hearing had taken place without further process. Salt Lake County has described why this is such an important issue, and it really is. However, it is the division's position that converting it from an informal process to a formal may not actually achieve any of the goals outlined, especially if there are appeal remedies to the board where that process would inherently be formal, because procedures before the board, the presumption is that they will be formal. Their second request for relief is for a site-specific reclamation plan. This is not required under the rules, the administrative rules, as well as the statute. And for that, we can also look to the declaration, the first declaration I've given you from Wayne Western, who has been with the division for numerous years, has a vast experience assisting in these permits, and he kind of outlines what is required for a small mine operation, and a reclamation plan is simply not required under the rules. An operation plan is, and there is one in place. The reclamation standards must be met, but a specific reclamation plan is unnecessary. Salt Lake County argues that there has been no evidence of coordination between the division and the county. And I would just like to point to the statute. Pull it up. So under the Utah Mine Reclamation Act, Utah Code annotated 40-8-5, we're going to look at subparagraph 2. It reads, if federal or local laws or regulations require operators to comply with mine land reclamation procedures separate from those provided for in this chapter, the Board of Division shall make every effort to have its rules and procedures accepted by the other governing bodies as complying with their respective requirements. So it's unclear to the division the substance of Salt Lake County's arguments that there hasn't been sufficient coordination between the division and Salt Lake County, where the statute seems to indicate that the division's rules As far as the division is concerned, the division's rules are what are really important. And to the extent there are differing rules and regulations, the division should be actively working to have those additional requirements reduced and conform to the division's requirements, rather than having the division enforce or approve or coordinate for additional requirements. The division strives to work with other governing bodies and sister agencies, but the division lacks the authority to enforce other entities' regulations. And that comes out pretty clear in the statute as well as the board order, which expressly states that just because the division issues a small mining approval for a small mining notice of intention does not mean that the potential operator can go and break ground. They still must comply with every other governing entity. Concerning the surety amount, we can look to the second declaration that I've given you, and this is by Ms. Coburn. So she describes that generally bonds for small mine operations are based on a per acre amount, which is approved by the Utah Board of Oil, Gas, and Mining. The standard per acre bond amount for small mine operations of 20 acres is $200,600 for 3 years, or $219,300 for 5 years. In this instance, she determined a higher bond amount and asked the petitioner to provide a $352,000 bond amount with a 5-year escalation. The petitioner has complied in this instance. During that process, Ms. Coburn, looked at everything available to her to ensure that there would be proper reclamation. It's her professional opinion that the surety amount is sufficient to provide adequate and complete reclamation in conformance with our rules. The objecting parties that have stated that reclamation surety is insufficient in this matter have not pointed to a specific area that they would like considered. The division is open to reconsidering a bond amount, but would need specifics rather than generalized statements of inadequacy. Salt Lake City has raised some really important issues concerning their water infrastructure that is heavily dependent on Parley's Canyon. These issues are of the most extreme importance. However, the division are not the proper experts to be making these sorts of determinations. For determinations concerning water pollution and water infrastructure, we rely on our sister agencies who have much more expertise in those fields. We rely on, Department of Environmental Quality, especially the Division of Water Quality. We rely on the Division of Water Rights and the state engineer for those determinations, and will continue to do so in this instance. Mill Creek has also raised a very significant and important issue concerning the fugitive dust and the potential health impacts. We are experts in mining reclamation. We're not experts in air quality, and we will rely on, again, the Department of Environmental Quality to make those determinations. And Granite will also have to, go before the Division of Air Quality if and when that becomes necessary to receive a permit and approval. Richard's family partnership raises an issue surrounding that this intention is for a large mine rather than a small mine. The rules and statute contemplate small mine operations starting out as small mine operations and later on expanding. This is a normal procedure, and should that take place, should Granite ever want to expand beyond 20 acres, even just a tenth of an acre, 20.1 acres, Granite would be subject to all of the requirements, including public comment, a site-specific reclamation plan, and operational plans at that time. But for now, under the law, under the statute and regulations, it is a application for a small mine notice of intent. And that's how the division should be treating it, and that's how the division is treating it. It's by following those rules. And that concludes our presentation, addressing the division's role in all of this. To the extent you have questions, I'd be happy to try and assist with those.
Thank you, Mr. Gruhl. I do have questions, and I'm not going to ask you to put words in any of the other objectors' mouths, but I do want to hear more about the division's opinion on certain elements. So you talked about the coordination between the division and the county or other jurisdictions. How does that coordination happen in light of what the board's order expects us to do? Because you said that the coordination would be more on the front end of saying how those rules could be more compatible with the division's rules. Yet the board order seems to contemplate that those approvals have to take place before the division can issue approval.
A strict reading, my strict reading of the board order indicates that those approvals need to take place before commencement of mining operations. However, the division could issue approval of a small mining notice of intention without groundbreaking actually taking place. That's how those two would square.
So in light of what you said about trying to get other jurisdictions to match division rules, what if that can never happen? Do we just live with the fact that there are multiple requirements out there on an operator?
Yeah, so the statute, the way that it reads, seems to contemplate that there are going to be instances where the rules are not going to square. So the next subparagraph that I did not read says the provisions of subsection 2A and D are established to minimize the need for operators and prospective operators to comply with duplicative, overlapping, or conflicting requirements. And you'll notice that it says, it doesn't say that the division and the board need to go in and tell these other entities that they must comply. It's just saying that the division has to the extent the division has a responsibility to coordinate with local zoning authorities and the federal administration, the division should be trying to get those other entities to match our requirements. We have no jurisdiction to go in and nor do we have the expertise in land management to go to a local zoning authority and tell them how they should zone their area. But to the extent there are differing requirements in a proposed mining operation, we don't have an obligation to enforce their requirements. We only have an obligation to try and get them to come on board with ours. Does that make sense, Director?
I think I understand that.
But as the subparagraph 2 mentions, this is to make it easier for the operator. To the extent that we can't fix those situations, the operator just has to deal with having duplicative or overlapping or dissimilar requirements. And that's on the operator to figure out whether it's worth going into an area that they're going to have to be meeting different standards that are separate and apart from the division's requirements.
Okay, I appreciate that. Let me look through my notes here. I know I had a couple of other things to bring up.
I'm sure you did. There's been a lot of excellent points made by the other parties.
I think you talked a little bit about converting from an informal proceeding to a formal proceeding. And if I heard you right, you said that conversion may not ultimately achieve practical objectives of the statute.
Yeah, depending on how that conversion takes place, the rules aren't super clear. They just say that the hearing examiner may convert an informal hearing into a formal hearing anytime before the decision has been issued. So in theory, that conversion could take place without any additional process. So the additional briefing, the Salt Lake County raises that argument with the assumption that that conversion would take place with additional briefing, additional hearings, ability to provide expert testimony and other forms of evidence. That isn't necessarily required in that conversion process. at least to my understanding, based off of our administrative rules.
Okay. If hypothetically, if we do not convert it to a formal process, I think you additionally stated that any form of appeal to the order I would issue would likely be a formal process at that point.
Yes, and I believe the board would be better situated to handle those formal, the formal adjudicative proceedings.
Okay, thank you. In regards to reclamation plans, and it may be in these declarations you gave me, does the division reserve review of reclamation plans for large mines only?
Yeah, so under the rules and the administrative rules and the statutes, reclamation plans are not required for small mine notices of intent. However, they are required for large mine notices of intent. So in this instance, if Granite were issued approval or, for this notice of intent, if they ever wanted to expand beyond 20 acres, they would need to go through and have a site-specific reclamation plan in accordance with the rules for large mine NOIs.
Okay. I know you said that the division relies on the expertise of other experts, those in DEQ, but it's, as I understand it, it may not be a requirement that we, if we receive advice or recommendation, that we follow that.
That's absolutely correct. Just like if we were to issue a recommendation to DEQ, they would have they can take it for what it is, which is free advice, and they get what they pay for, I suppose.
Okay.
And I just want to reiterate, Dana Dean with me wanted to make sure we get on record that small mine NOIs don't require this reclamation plan that's site specific, but they do have reclamation standards that are exacting and that will ensure, stability. And that's kind of outlined in Ms. Coburn's declaration, that she believes, based off of the reclamation standards and the surety amount in this instance, that full reclamation will be able to take place at the end of this.
Okay. So I know we've had some very good presentations today. I'd like to give Granite Construction an opportunity for a last word at this point, based on everything you've heard, to see if your original statements still stand at this point, or if you want to respond to anything that's been said.
Thank you, Director Baza, and thank you to all of the objectors and the division for the comments today. I would like to just respond to a few things. First, I think this is abundantly clear, but this is not an application for a large mine. This is a small mine notice of intention. I've heard several comments today and read in the written objections reference to the NOI really being, in its essence, a large mine NOI. That is not the case. The plain record is exactly the opposite. And I'll also note that this small mine notice of intention was filed consistent with a stipulation that was entered, which the division agreed with, Tree Farm agreed with. The parties agreed on this process. Several of the objectors who are here today were part of that prior proceeding in which the stipulation was entered, and no objection was lodged to the stipulation. And this is simply following through on what everybody agreed would happen: a refiling of a small mine notice of intention to correct the procedural dispute about the simultaneous filing previously. That issue is now done, gone, over, and resolved. This is a brand new small mine notice of intention, which should be reviewed according to the rules. The next item is reference to the board order, and some comments were made about Granite maybe not recognizing the existence of the board order. That is not the case. Obviously, not true at all. Granite recognizes that the board order was issued. But let me make a couple of notes with respect to the board order. The objectors are taking a very broad and very self-serving reading of the board order. The objectors consistently referenced that the board order was clear with respect to certain matters. It's not quite as clear as objectors would assert. In fact, the board order was the subject of legislative committee action. And the Administrative Rules Committee had very particular concerns about what the board order said. Now, I'm not going to go into the details of that separate hearing and proceeding, but the board and the division gave statements about their interpretation of the board order and whether it affected or didn't affect the current regulatory scheme. And those statements speak for themselves, and they're part of the public record. On the request to convert these proceedings from informal to formal proceedings, as was noted during the hearing, the standard is that the division or the hearing officer may convert them if it's in the public interest and does not unfairly prejudice the rights of any party. We agree with the division that this proceeding should not be converted into a formal proceeding. It would unfairly prejudice Tree Farm and Granite. Despite the objectors' couching of this request in terms of additional process and fairness, this is a delay tactic. The intent here is to try to make this process more expensive and more burdensome and more cumbersome for this operator. Small mines have limited disturbance, they have limited impact, and the legislature has already decided that these types of applications are reviewed on an expedited basis. Moreover, a formal proceeding to review a small mine notice of intention has never been done, to my knowledge. There's no precedent for this. It would be extremely, it would be brand new. It would be a matter of first impression that, to my knowledge, has never been done. And I don't think it reflects the legislative intent or the board's intent as reflected in the statutes and the rules. Finally, on that point, this is a matter of division discretion. It's not a requirement. It's not a mandate to convert from formal to informal. It is within the division's or the hearing officer's discretion. It's a discretionary matter. On the site-specific reclamation plan point, we agree with the division that no site-specific plan is required and that the rules provide reclamation requirements, and the requirement for the operator is that they commit to following those reclamation standards set forth in the rules. Those must be followed, and those will be followed. Granite has indicated as much in the notice of intention. With respect to the reclamation amount, we agree with the division and Ms. Coburn's declaration. The reclamation of the form and the amount of the reclamation surety are sufficient, and we've heard nothing other than general allegations to disprove the sufficiency of this reclamation surety. On the point regarding Salt Lake County's additional mining requirements or additional land use requirements or other requirements that may apply, I would refer the hearing officer here to 40-8-5 2D, which is part of subsection 2 is part of what the division read, but we didn't quite get to subsection D within that statute. And that statute says, an ordinance or regulation issued by a political subdivision of the state that is more restrictive than a permit issued under this chapter for a mining operation on state or federal land is unenforceable. The legislature is trying to indicate here that the political subdivision and the local government regulation authority is limited. Now, I fully acknowledge that subsection D refers specifically to state and federal land, mining operations on state and federal land. So it's not directly applicable here. But the intent of this statute is clearly to say to local governments, political subdivisions of the state, the Division of Oil, Gas, and Mining has primacy here and is the primary mining regulator. And that's reflected in what the division read in the earlier subsections of that statute. Finally, with respect to expansion, we agree with the division that a large mine notice of intention would be required if there were ever a point in time where a disturbance larger than 20 acres would be required. That's why the small mine NOI references the mine enlargement statute, because that's the standard for expansion. Otherwise, Granite is limited to a maximum of 20 acres of disturbance. No more, no expansion under any other terms. The stipulation contemplates this, and we, again, agree with the division that a large mine notice of intention would need to be filed if expanding. So that concludes our comments. We would urge the hearing officer here to take into consideration all of the comments that were made here, and we would ask that the division issue its determination that the NOI is complete and that the form and amount of reclamation surety are sufficient. Thank you very much.
Thank you, Mr. Wallen. I will want to make a closing statement to close out this hearing, but I would like to confer with my counsel at this point. So give me a brief opportunity to do that, and I'll be back shortly.
And Director Baza, if we could be given a brief opportunity to make a few points. We've seen some new things we've not seen before. We'd appreciate it. Thank you.
Shall we do that? Just give me a minute. I need to respond to Mr. Zodi's request. Mr. Wallen, how do you feel about that? I know we've had everybody provide their comments. I think the written comments can still be provided before this coming Monday. It belabors the hearing if we allow additional statements at this point.
I agree with you.
Okay. So
Can I make a record on that, Director Baza?
pardon me,
Can I just make a brief record on that, Director Baza?
a brief record. What do you mean?
I just want to have a few things that are on the official record about our.
Okay. That sounds fine.
Thank you, and I appreciate we've been here a while. And all I want to do is primarily respond to the new points we've heard, particularly the division has submitted some declarations. We did not understand this was a hearing for evidence. It said it was oral argument. There were some points they made. So if we were given 5 minutes, I can make those briefly and be done. We would not extend it very long. And so I think we did file the objections. It would be appropriate, I think, typically the objectors get to go last and also respond to other things that come up in a hearing. That's the typical practice, but that's your call.
Okay, let's allow it.
Okay.
Try to keep it short.
Thank you. I appreciate it. Yeah, there were 2 declarations filed by the division, and we appreciate the division's presentation. And I think one thing, the division hasn't really helped you navigate the board's order very well. not a lot's been said about that by the division. And it feels a bit like the division is not focused as much on that as maybe the objectors are. But I think you have to navigate that. These are the first time we've seen these declarations. They're fairly short. The declaration of Kimberly Mary Coburn Grunwald, the division said it would be open to getting more information about the bond if specifics were given. This is the first time, we've seen any detail about the bond in terms of how the division views it. So I'm not sure how the division views the opportunity to get more information about this calculation. If further process were allowed through your order, that would be one way. In terms of coordination with the county, I just read and relied upon the language of 40-8-14.4. We're not asking for anything other than what the statute says, and some degree of coordination. I don't know how the division handles that in practice. And that's really the main point there. And they've cited other provisions that you'll have to consider, of course. Let me see. I would take issue with the project proponents' statement that these are just delay tactics. I think you've heard legitimate concerns expressed from multiple angles by various governmental entities and the public about this specific project. There's no question it's a unique project, including for the reasons the board has said. So the board order is there, and so we're just reading it and trying to follow it. As to a legislative hearing, I really don't think that's part of this proceeding. I'm not sure the point of that. I'm bringing it up here. I don't think it would be appropriate at all to discuss that in any order. Sort of a separate process if there is any legislative changes or other thoughts going forward. That's it. We really appreciate the opportunity and that you have to struggle with these issues. Thank you.
Thank you. And again, I'd like to take a few minutes and confer with my counsel on this. So let's go off the record for about 10 minutes and I'll be back shortly. Ladies and gentlemen, could you please take your seats? Paul, you want to give me a heads up as to when we're ready to go back online?
Director Baza, recordings are active again. Thank you.
Okay, thank you very much. Our court reporter is ready.
Director Baza,
Yes.
Trevor seems to still be gone.
Ah, okay. Let's hold off until Mr. Gruhl gets back in the room. Okay, I'm going to provide a brief closing statement. First of all, I want to thank everybody for the time they took to address this. You've raised some very interesting and very appropriate issues at this point. The final order that I'll be working with council on to produce hopefully can address some of the things that were raised today. This is a complicated matter. It's impactful to many people. We will try to do our best to address the issues as part of the order that comes out. The philosophy I've always had in my role as the administrative head of the division is first and foremost, we need to be consistent in how we apply the rules in the statute. We will be paying close attention to the board order, making sure we are consistent with that. And I want to clarify the comment deadline because I misstated it at the beginning. We are expecting written comment to show up on that division's email site by Monday, 5 p.m., this coming Monday, July 18th. And the reason for doing that is we know that there is a deadline for me issuing an order as part of this hearing. We are doing our best to comply with that, but there are some complicated things. For example, the whole Department of Natural Resources shutting down on the 22nd of July. Then we have a state holiday the following Monday. So we will issue an order as quickly and as soon as we can get back to business after that happens. So I know that there is a deadline on this. We try to be expeditious, but we'll certainly meet our requirement to issue a timely order on this. Again, thanks to everybody. I recognize that it's affecting a lot of people's lives, so it deserves this extra attention that we're giving it. But with that, all I can say is appreciate all of you being here. Try not to burn up in the heat and enjoy the rest of your week. Thank you.
Thank you, Director Baza.
Thank you, Director.